Thomas and I both worked on the dialogue process and also the Uluru Convention, so we thought we might say a few words each about treaty in the context of the Referendum Council's process that just occurred, and also where we're going from here. So when we received our terms of reference from the Prime Minister and Opposition Leader as a Referendum Council to go out to communities and conduct dialogues with Aboriginal and Torres Strait Islander communities about what constitutional reform or what meaningful recognition is to Aboriginal people, agreement making or treaty obviously wasn't on that list. However, because of particularly the process that had been set up in Victoria by the Victorian government on negotiating a framework agreement, we did say to the Prime Minister and Opposition Leader that we couldn't go out to communities and not talk about the elephant in the room. And that is to say, the aspiration of Aboriginal and Torres Strait Islander peoples since the very early days for some sort of treaty settlement or agreement making. And so we got permission then from the Prime Minister and the Opposition Leader to do that. So when we went out and held our dialogues in communities, agreement making was a part of that discussion. And so, obviously a very central part of that aspiration has been for those agreements to be with the federal government. That is to say, Aboriginal and Torres Strait Islander communities and the federal government negotiating mutually agreed terms to guide future engagement. But it is a federal system, it's a federation, and I know for academics who study treaties, like Marcia and I, who are writing a book on treaty, we were very pleased to see that South Australia and Victoria move towards this process. And I say that because we talk a lot about treaties in Australia, but they're very difficult things to get to. They involve one of the most important parts of treaty or treaty making is the process, and it takes a long time to get to the outcome, and we have not done that in Australia, except for the point that Marcia made earlier in relation to native title and land rights and agreement making in that context. So the communities that we visited under the expert panel's work in 2011, and I note that Fred Chaney is in the audience, who was a part of that expert panel. When we went out to communities, one of the key things that they wanted at that point was treaties or agreement making. At the time, we felt that we couldn't make that a recommendation of the expert panel. So it was no surprise then when we went back to communities that treaty making or agreements were a really prominent part of the Referendum Council's dialogues. So in the dialogues, though, we had to discuss the pros and cons of what treaties look like, drawing upon what we know around the world in terms of comparative examples of treaty making. That, of course, is a difficult thing to do because a lot of treaties were signed at first contact, but for those jurisdictions that have what we call post-colonial treaty making. So there's a lot of experiences and examples we can draw upon and did draw upon around the world to illustrate what the pros and cons might be. I mean, of course, one of the major arguments in favour of treaties is the legitimacy that it gives First Peoples within a state. That is to say, it recognises authority structures and recognises pre-existing property rights. I suppose one of the discussions around the voice and why the voice or this idea of an institution to the Parliament it was so prominent in the discussions and the dialogues is because of those two things. There has not been that legitimacy afforded to Aboriginal people in terms of a recognised authority since the arrival of the British, nor was there recognition of their pre-existing or our pre-existing property rights. And I think that was also manifested in I say it was unexpected, but I suppose it's not expected, and that is to say the huge emphasis at all the dialogues that was put on truth-telling, on truth. Because if you don't have that legitimacy within the public institutions forged at that very first kind of creation of the nation, then it's very difficult to make the case later down the track when you're retrofitting. And I think that was the kind of essence of that call for truth-telling as we moved around the country, and the lament that so many Australians didn't know Aboriginal history, the stories of dispossession, which were stories of massacres and the frontier wars. And I think Noel Pearson makes this point very eloquently in one of his quarterly essays, where he says the political economy of the Australian nation was killing. In order to get the land to build the pastoral industry, they needed to move these people who were not leaving off those lands. And that is that is Australian history. And so these stories were really prominent as we moved around the country. Not stories we hadn't heard before, but unless there's an appreciation of those stories, then it's very difficult to argue the logic for treaties or agreement making now. And that is to say, we are unusual in the common law world that when the British arrived, there was no rivalled authority for the land. The lack of articulation of that is to say, the steadfast non-recognition of our people as having no structure or authority or property rights is a unique part of Australian history, but also unique in the world. That is to say, when the British arrived, they took a very mercantile, early capitalist approach that informed their theorising about the colony, the early colony. So that lack of articulation through a treaty is really rare, because the Crown did use treaties as the primary way of engaging with peoples when they established new colonies. That does lead to then some of the cons of treaties, which we discussed in dialogues. And that is to say, one of the downsides of treaties via the Crown is that you enter in the realm of public law, of the legalism that comes along with Crown agreements. So we know that the common law then, in countries that did have first contact treaties, provided the sole means through which Aboriginal peoples or populations' political integrity and culture and land was legally vindicated. And as Paul McHugh, the scholar on the New Zealand scholar who's at Cambridge, who writes on treaties in the common law, he said that for countries, for Aboriginal groups, their institutions then fell under the cold reality of life inside the compass of common law constitutionalism. So legal ritualism defines then treaty making. It defines who Aboriginal people are, what their rights are. These agreements are legal documents. So what we did hear in the dialogues was a lot of interesting stories from a lot of Aboriginal people who had visited places like New Zealand and Canada and knew a lot about the legalism that is associated with treaties. That is to say, it becomes the courts and lawyers who interpret the terms of those agreements. You see firms established that become experts in interpreting these agreements. It is a very legalistic approach on the other side of a treaty once it is negotiated. So treaty making is a very complex thing, and so in many ways we're very fortunate that Victoria and South Australia have moved towards the process of negotiating agreements with their peoples. I know that in Victoria there will be a representative body created which will give Aboriginal Victorians the cultural authority and leadership to determine what their agenda is in terms of treaties going forward. So there's many different approaches to process. And I think for us, in relation to the work of the post-referendum council, what does the Makarrata Commission look like? How does this fit into the aspirations of people coming out of the Uluru Statement from the heart, which was a voice, treaty and truth? There will be really important lessons coming out of South Australia and Victoria in relation to the process of agreement making going forward. The final thing I'll say is what we think came out of the dialogues in terms of the shape of what a Makarrata Commission might look like. It will, of course, be localised agreement making. And in addition to that, part of that localised agreement making will be the component of truth-telling. That is to say, it was envisaged that the mapping of Australian coexistence, the mapping of the massacres and the frontier war, the mapping of Aboriginal history will be done at that localised level. I'll stop there and let you say a few things, Thomas.